Rock and roll.
Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery Today's Doug Austin called the Important eDiscovery Case Law Decisions for June of 2022. Our faculty experts are Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. This webinar will be recorded and available for your replay at your convenience, as is every month's webinar. And please take a look at the attachments tab. We've got a link to Tom O'Connor's Spicy Techno Gumbo blog, a place to learn more about Judge Peck, and our next webinar on practical steps to build a knockout personal brand that will feature both Doug Austin and Kaylee Wellstad. So you can look for that. And introducing our panelists, we've got Doug Austin, editor of our EDRM partner, eDiscovery Today, with over a decade of experience in the trenches of eDiscovery, and he is writing and posting multiple times each business day, but at least once since 2010. Doug earned Reader's Choice Awards from JD Super and eDiscovery and Cyber, which we believe he will win again in 2022. And Tom O'Connor, hailing from the great city of New Orleans. For 3 decades, he's stewarded the Gulf Coast Legal Technology Center. He is a sought-out consultant on some of the largest cases, and most recently, the opioids. And the Honorable Judge Andrew Peck retired as a federal magistrate judge in the Southern District of New York after 20 years, writing many of the first foundational opinions on eDiscovery generally, keyword search terms, boilerplate objections, the beloved 502D orders, and technology-assisted review. He's a graduate of Duke Law School. Now with DLA Piper, he advises on information management, particularly in the eDiscovery context. He also acts as a mediator, arbitrator, and special master. And EDRM is grateful to all 3 gents for serving on our EDRM Global Advisory Council. Now, Doug, do you have some cases for us?
Yes, I do, Mary. We've got another 6 interesting and unique cases this month, and they include cases involving waiver of privilege with a protective order, communications and cooperation during discovery, forensic imaging of devices and dispute over that, adverse inference sanctions for spoliation of video and intent to deprive, interference with the third-party production, which will be very interesting, and a proportionality analysis of search terms. So some pretty cool cases this month. And as always, we'll look to hopefully save a few minutes at the end for questions, but we encourage them along the way as well while we're discussing each case. Just a reminder, because I'm sure someone will ask at some point, we will send a copy out of the slides after the presentation, so look for that. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. The year may be almost half over, but disclaimers are never over. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery Today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 23,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Source is the definitive source for eDiscovery case law out there. By the way, did you notice anything different about the slide this month? That's a picture of the state cases map. eDiscovery Assistant has plenty of state cases in its library as well, some of which we've discussed right here. So, with that said, let's get into our cases. And our first one was suggested by Judge Peck. SureFit Home Products versus Matex Mills is a patent infringement case related to a shower curtain design where the plaintiffs produced exhibits 88, 89, and 90 to the defendants. When the defendants served plaintiffs with their first set of requests for admissions, which included requests to confirm the authenticity of the 3 exhibits, the plaintiffs responded to the request for admissions, asserting privilege only over Exhibit 89. But then subsequently, during a meet and confer, the plaintiffs finally asserted for the first time that all 3 exhibits were protected and sought to claw back the documents per the protective order the parties agreed to. This case involved a little bit of deja vu all over again, as the plaintiffs had also used the documents in a prior matter, where the Cartry defendants, in that case, used the 3 documents as a combined exhibit to a reply brief in support of their motion for summary judgment. The plaintiffs never objected to the use of the document then, nor did they assert attorney-client privilege or work product protection as an objection to their use as a trial exhibit. Citing the plaintiff's completely reckless handling of the purportedly privileged exhibits and the presence of a protective order, New York Magistrate Judge Gabriel Gorenstein noted, "Courts have held that where parties execute such an order, waiver is appropriate only if production of the privileged material was completely reckless, and for a production to be completely reckless, the producing party must have shown no regard for preserving the confidentiality of the privileged documents." Ruling the plaintiffs waived privilege on the 3 exhibits, Judge Gorenstein stated, "The plaintiff's reckless conduct is heightened by the fact that plaintiffs necessarily had to carefully review the documents more than 3 years ago. Rather than taking any action, however, plaintiffs did nothing to object to the use of the documents in the Cartry matter, and then again produced the exhibits to Matex 2 years later. This course of conduct, spanning several years, 2 disclosures, and multiple clear opportunities to claim the privilege, evidences a total disregard for the confidentiality of any of the documents." So, Tom, do you think the privilege designation in this case was a last-gasp effort to keep the exhibits from being used, given that they were used in the previous case without a privilege objection?
Honestly, I don't know what they were thinking here, if they were thinking at all.
Right?
As the judge said, and this is pretty funny, the word reckless was used several times, and not just reckless, but completely reckless, like shades of A Few Good Men. I don't just object, I strenuously object. I'm just baffled. And it wasn't just one case, right? It was 2 cases. They were introduced, pointed out that they were privileged, and then used again in a case after that. It was like, I'm just baffled. Were they asleep at the wheel? Do we have a precursor here to the Hanlon's razor that we're going to talk about a little bit later in another case? As that great eDiscovery consultant Sherlock Holmes once said, and I'm paraphrasing. I'll turn to Judge Peck for the actual quote here, but something to the effect of that when you eliminate all the other options, whatever remains, however improbable, is the truth. Sign of the 4, Judge Peck?
Well done. It's actually, he said it in at least 2 cases, and that's a pretty fair paraphrase.
Yeah.
I also want to note that I appreciated Doug's deja vu all over again. A little shout out to the great baseball philosopher Yogi Berra.
Yeah, there you go.
There you go.
So yeah. Honestly, I don't know, Doug. I mean, you would think that maybe they were trying to, get one last shot at it, but they had been so recklessly careless before. At one point, the judge, in another part of the decision or the order, said it's the highest degree of carelessness in handling the privileged material. So I don't know. It's a puzzle to me.
Yeah, me as well. And the judge certainly made it pretty clear how reckless they were, which made me wonder if it was just kind of a last gasp effort. Yeah. So Judge Peck, could Rule 502D have saved the plaintiffs in this case, or was it too late once they failed to claim privilege in the previous case?
Well, funny you should mention that, because I was sufficiently interested in what the heck was going on here that I went to the docket and pulled the joint letter that the parties submitted to the court in advance of what became Judge Gorenstein's order. And at least according to that letter, the prior protective order agreement, whatever they called it in this opinion, was indeed an order under Rule 502D.
Oh,
so,
Oh,
This may be one of these bad facts make bad law. I mean, technically under 502D, the production here would not be a waiver. As you know, 502D allows you to be as careless as your malpractice carrier will allow you to be, and you still get to claw it back. The problem is there is no evidence before Judge Gorenstein, and that's all I'm relying on is his opinion and the motion before him that they had a 502D order in the prior case. So this may be a situation where he could have phrased it better, but that the production here was just the icing on the cake by the fact that they had waived it in the prior case, and you can't use, as great as 502D orders are, you can't use them to unring the bell on prior, before there is a 502D order, waiver by production. So, bad facts make bad law. This opinion could have been written more precisely, but it's sort of you miss so many opportunities to say, oh wait, this is privileged, I didn't mean to produce it, I want it back, that 502D really can't save you here.
Okay, well, because we have Mary, I'll get to you in a moment, but we have a question from the audience. Why does it matter whether waiver was achieved through production, given that waiver was separately achieved through use of the privileged documents as exhibits? So, and they point out your 502D template agreement doesn't protect against waiver by use of privileged materials. So, comment about that, Judge?
Yeah, I mean, we discussed this several months ago in the Klein against Facebook case where a privileged document was used at a deposition, or might have been, because this was drafting the protective order in advance. What happens if the other side uses one of your privileged documents at a deposition and you sit quietly and don't do anything? And the judge there said, well, design your order so you have to issue your clawback within 10 days of the receipt of the transcript. Here, unclear who was using these as exhibits. I mean, if the party whose privilege it was using them as exhibits, then it's sort of like, how can you claim inadvertence or that 502 should let you get them back when you used it as an exhibit? But it wasn't clear to me here who was using it as an exhibit in the prior case.
Right. Yeah, that's true. So yeah, that's a good point. So Mary, obviously, we've had some discussion about this, and I guess my question is, what good is a clawback agreement if your handling of documents in the previous case helps invalidate it if you inadvertently disclose them again? And really, what could the plaintiffs have done differently to protect themselves from waiver in this case?
I would have thought that they would have had to assert the privilege in the previous case, rather than take it to the highest octave of using it as an exhibit or allowing it to be used as an exhibit. So I don't know that they could do anything other than that and then raise the 502D order. But if they have nothing to hook it on, yeah, they've got nothing.
Yeah, absolutely. And yeah, this was a very interesting case about privilege waiver, and certainly it looks like a couple of folks disagreed with kind of the handling of it. One comment here, we've got several comments, so I won't be able to get to all of them. I agree that the decision should have been decided on retroactivity, not on the completely reckless standard. So, very interesting case. But we have 5 others to cover, and so I will move on to the next one. And our next case, Ravikant versus Rodi, was also suggested by Judge Peck, and it's one where the plaintiff violated rule number 1 in dealing with the court. If you've been watching our monthly webinars, you know what rule number 1 is. If you haven't, Judge Peck will tell you in a few moments. Regardless, in this medical malpractice case arising from adverse consequences in the days following plaintiff's surgery, New York Magistrate Judge Ona Wang opened her order with this statement. Since the case was referred to me in May 2021, plaintiff's counsel has needlessly multiplied and complicated discovery. Significant judicial and legal resources have been devoted to resolving these unnecessary disputes. Not a good sign for the plaintiff. So what did the plaintiff do? Among other things, the plaintiff demanded that defendants immediately deliver their complete office and medical charts comprised of every discoverable document in their offices by the close of the next day. They sought an order shortening defendants' response time from 30 days to within 5 days of the date of an entry of an order. They served discovery requests seeking to inspect a Doppler imaging machine at the height of the Delta surge, then sought documents in a 30b6 deposition from all defendants to address why they hadn't been able to produce discovery. And they served defendant NYPH with a notice of deposition, with the deposition set to occur 4 business days later regarding the existence, location, and production of metadata related to defendants' interactions with the EMR, or alternatively producing the metadata within 15 days. Judge Wang noted that the defendants filed a motion for a conference, but construed it as a motion for a protective order, which was granted. Judge Wang also granted the defendant's request to file a motion for fees and costs and stated, the court has previously voiced concerns about proportionality and unnecessary motion practice as it relates to plaintiff's demands for additional records from NYPH, among other things. The current issue before me epitomizes unnecessary motion practice. Plaintiff seeks, on an unreasonable timetable, depositions and documents that are substantively duplicative of what he already has. Plaintiff has repeatedly made discovery requests and sought court intervention in a manner that has needlessly increased the cost of litigation and has been unduly burdensome or expensive considering the needs of the case. So, Judge Peck, of course, the plaintiff broke rule number 1 in dealing with the judge, but where do you draw the line? How could they have pursued discovery differently to get what they wanted without violating rule number 1?
All right, for those who are either searching in the rule book or haven't been listening for the last year plus, to me, Rule 1.1 or 1A, or however you want to describe it, is the rule not written down anywhere, but common sense, don't piss off the judge. And clearly, that's what plaintiff's counsel did here in front of Judge Wang. I mean, what should counsel have done? Not ask for ridiculous information and on short time frames not covered under the federal rules. So, for example, as shown here, one of the requests was to NYPH, New York Presbyterian Hospital, one of the biggest hospital chains in New York City. And as I read it, it's all medical records, period. Not all medical records about the defendant, but all medical records. I mean, that's every document in the hospital, and, HIPAA be damned. So often one needs to think about what you're asking for and how that request will be perceived by the other party in the first instance or by the court when it gets to motion practice. And either plaintiff's counsel here was incredibly clueless, both about the federal rules and about medical records, or was doing it to harass the defendant. Either of those violates 1.1. And I'm glad to see that Judge Wang, even though it's a pain in the neck to have to deal with a sanctions cost motion, allowed the defendants to make such a motion.
Yeah, absolutely. This was it was pretty extreme. So, Mary, it seems as though one of the problems was that plaintiff's counsel kept changing their mind about what they wanted in discovery. And so, do you agree? And what can parties do to develop an eDiscovery plan that they can stick to?
Now, I looked at that and I was like, what are they thinking? But this is an individual plaintiff, and they had 3 different law firms working on the case. And maybe that's why there were so many different kinds of requests. Well, one thing about the metadata, they said that they had produced metadata showing the times and dates of the medical provider's entries. But what they were after was the metadata that would confirm the allegation that the defendant failed to review or improperly reviewed and failed to interpret. So that's like viewing, printing, that type of metadata. And I think they didn't parse that properly. But in terms of developing an eDiscovery plan they can stick to, perhaps they could all those law firms could agree amongst themselves what their plan is, and then go forward and execute it. And the other thing I saw there is that they shortening dates, and I looked at the dates of compliance, and they look pretty good. So it didn't look to me like they had too much to complain about, but they were complaining way too much.
Yeah. Certainly seen that that was the case. So Tom, Judge Wang said the plaintiff's actions were unduly burdensome or expensive considering the needs of the case. Had it been a medical malpractice case with multiple plaintiffs instead of a single plaintiff, could that have changed how unduly burdensome the actions and requests were?
Well, sure. It would make it worse, right? I mean, you know, we've got off the judge list of the plaintiff's conduct. You've got number 1 was immediately deliver more or immediately deliver complete office and medical charts. The judge said every document in the office by close of the next day. So 1 plaintiff. Well, if it's 10 plaintiffs, and it's 10 times as many documents, right? And then deposition notices for. It just seems like it would incrementally make this even more burdensome by adding more plaintiffs into the case.
Yeah, certainly could. And it was definitely, if we can't say it enough, rule number 1, don't piss off the judge. So there we have it. So we'll move on to our next case. Let's see here. There we go. Ooh, no, it jumped 1, 2, 10. Okay, there we go. All right. And our next case is a case from Illinois District Judge Ian Johnston, and it's not 245 pages long.
Yay.
Right. Not that it's short exactly, but we'll take it. In Hollis versus Siva Logistics, U.S., a case involving claims of discrimination and wrongful termination of the plaintiff, an incident happened between the plaintiff and the coworker where 2 sets of witnesses had differing accounts, with 3 witnesses who were white claiming the plaintiff put his hands on the coworker, and 3 other witnesses who were African American claiming he didn't. The defendant ultimately chose to believe the 3 white witnesses, and the plaintiff was fired. Even though 3 security cameras were aimed at the area of the incident, the defendant presented no evidence that any of its employees ever attempted to view, preserve, or recover the footage before the plaintiff's termination, nor was it preserved to address his EEOC complaint or eventual lawsuit. The plaintiff had verbally requested the general manager to review the video recordings, and about a week later, in a document complaining about race discrimination, twice requested a review of the video recordings that he claimed would clear him of wrongdoing. Despite all that, the video was ultimately lost. Judge Johnston evaluated Rule 37E's 5 threshold requirements regarding spoliation. On the first one, the information must be ESI. He rejected the defendant's argument that the burden of proof that the video existed resided with the plaintiff, stating, under Siva's theory, as a practical matter, the spoliation itself prevents a claim of spoliation. He also cited the plaintiff's formal letter of complaint sent the day after his determination as satisfying the second requirement, and found the remaining 3 conditions had also been met. And he also found that the plaintiff was prejudiced by the destruction of the video. But when it came to intent to deprive, Judge Johnston stated, plenty of evidence exists in the record that could lead a reasonable person to conclude that Siva acted with intent. referencing, for example, how the defendant cited the seller of the video equipment as the custodian of the security video when they had no role in that process. However, when considering the intent to deprive decision, he also stated, a competent counsel who is willing to argue that her client is not inculpatory but is instead incompetent could make a reasonable argument that the failure to pull, preserve, and peruse the video recordings was not intentional. He also referenced, as Tom preluded, Hamlin's razor, which says in its most polite form that we should not infer malice from conduct that can be adequately attributed to incompetence. The impolite form substitutes the word stupidity for incompetence. Regardless, Judge Johnston decided to leave the intent to deprive decision to the jury and provided an appendix of factual findings and instruction that he planned to give to the jury during the trial. So, Mary, this seems like a failure to execute a fairly simple legal hold. Why do you think parties keep failing to properly execute legal holds when there are so many resources that provide guidance how to do it?
Well, it's interesting. You call it an easy or a simple legal hold. I think the simple legal holds are for things like Office 365, file shares, and things like that. Once you veer off into social media, collaborative apps, or audio, video, those systems aren't really well understood by many in the legal community. You had mentioned how the defendant cited the seller of the video equipment as a custodian of the security video, even though they had no role in the actual process. But they had used that video evidence in a previous case. So had they had a living data map, they would have updated it at that point, and they would have been able to execute a good, effective legal hold there. But I would say budget constraints, and then also the way that sanctions have been weakened over the years have made it not a top priority to issue appropriate legal holds and preserve the way that pre-2015 there were all sorts of draconian sanctions if you didn't do it right.
Yeah, well, that's a great point. So Tom, Judge Johnston cited Hamlin's razor as part of his reason why he didn't infer intent on behalf of the defendant. Do you agree with that, considering, as Mary just alluded to, the defendant identified the vendor who sold the equipment as the custodian of the security video?
Well, yeah, I think, as the judge pointed out, that was a factor, but there were many other factors, as he said in your quote, plenty of evidence, end quote, that could lead a reasonable person to conclude that the good part of Hamlin's razor should be in play here, that there was not malice. He didn't go so far as to say incompetence, but basically said, there's enough different factors at play. Let's leave it to the jury to decide.
Yes. Well, speaking of leaving it to the jury to decide, Judge Peck, do you believe juries are qualified to make intent to deprive determinations? Would you have done so in this case, or would you have made the determination yourself?
I mean, I have great faith in juries. I mean, in all the jury trials I had on the bench, the jury got it right, except for a small piece of one trial. All the other times, and some were fairly complicated matters. So the jury has the competence to do it. But, two things to think about. One, at this stage of the case, would there be enough evidence to get to summary judgment for the plaintiff or not? Is deferring this question to the jury effectively throwing out the likelihood of summary judgment and forcing the parties to go to trial, etc. Secondly, often, this one, I think it's fairly simple. Did the person who made the decision to fire the plaintiff, get the video? And if not, why not? It's not very complicated. But in many other cases, it's a question of what was done to search. Was it the lawyer doing it? And you don't want to have lawyers testifying as to this issue while they're at the same time presenting the case to the jury. Finally, I think Judge Johnson could have gone at least one step further and required a statement, a stipulation, a proffer, whatever you want to call it, as to whether the defendant was willing to fall on the sword of incompetence. Don't wait for trial for that, to see if the defendant was going to say, oh, yeah, we didn't do it with malice. We're stupid. I think he could have required the defendant to make that decision immediately after the court's order.
Sure. Well, yeah. A question from the audience: would this be an appropriate case for discovery about discovery and asking the defendant to produce information about its legal hold process and hold notices to help make a decision on intent to deprive? Would that have been something that could have been appropriate here?
I mean, I generally do not approve of discovery on discovery, but this is a case where, assuming that evidence wasn't already developed, and often you don't know what exists that the judge didn't mention in a published opinion, but assuming there hadn't been inquiry into that, sure, asking the supervisor, Mr. Hollis asked you the day after that event that led to his termination to go look at the videotape. Why the heck didn't you? And things like that. What is the practice of the company to save videotapes of incidents that were caught by cameras, et cetera, et cetera?
Right, especially when they had another incident where they had gone to the tape. So yeah, absolutely. Very interesting case, and be interesting to see if we can follow what happens downstream. So, but for now, we'll move on to the next case, which is Jordan Con Music Company versus Taglioli, a RICO case alleging continued criminal copyright infringement of unlicensed software as a predicate act. In this case, the court held a discovery conference to hear arguments pertaining to the plaintiff's request that the defendants make their devices and means of data storage available for imaging and inspection, along with details of their licenses for all software used for their business, asserting that this imaging was crucial to their RICO claims. Defendants responded that the discovery request was far too invasive, that turning over devices and data would produce information beyond the scope of any claims in this case. Texas District Judge Amos Mazant, after confirming the plaintiffs had RICO standing in his court, denied the plaintiff's forensic imaging request, stating, even assuming plaintiffs have RICO standing, the court must deny the motion to compel. Though plaintiffs attempt to simplify their request with straightforward language, the reality is that the request is massively disproportionate to the issues. Plaintiffs hope that through the forensic examination, they will find evidence of unlicensed and cracked software that defendants used to skirt paying licensing fees. They may very well find such evidence through the examinations. But as defendants assert, plaintiffs will also become privy to information far beyond the scope of audio software, including programs and applications such as personal hospital health portal applications, personal banking applications, dating apps, and other personal sites, Super Mario Kart, Photoshop, Solitaire, and other purely non-business programs. This does not meet the proportionate standard under Rule 26. But Judge Mazant noted in the second set of interrogatories, plaintiffs requested that defendants, among other things, identify computers, storage mediums, and software used in defendants' business within a specific time frame. Defendants objected outright. This information is directly relevant to the RICO claim because it could uncover information regarding copyrighted software and the time frame for which any alleged infringement took place. The court finds this method of discovery is proportional to the issues, and it is far less invasive than a forensic examination of all the defendants' devices. The court therefore expects defendants to forego their boilerplate responses and objections and provide detailed responses to the interrogatories they've been dodging at every turn. So the plaintiffs got some satisfaction, but is it enough? Let's see what Tom thinks. So Tom, do you believe the plaintiffs can get the information they seek about unlicensed software without a forensic examination?
Well, I think they can start. I mean, I think, the point is, and I advise clients on this all the time, start with your plain old discovery, interrogatories, requests for productions, and see where that leads. And then if something pops up where we have to go in and ask for a detailed forensics examination, maybe the court would look at it. Obviously, the court was concerned with the invasiveness, right? The fact that just an overall forensics exam, turn the computer over for them to look at, would reveal or give access to just an abundance of PII, as well as things that were not at all relevant. Super Mario Kart, which says something about their gaming preferences, but probably nothing about the litigation. And that's just too much. So I think, you start with the focus. I do think that last sentence you just read, though, there was a second factor involved there, that the judge pointed out their, quote, use of boilerplate objections. What he said, forego their boilerplate responses, and the interrogatories they have been dodging at every turn. I think if they have not breached Rule 1, they're certainly on the cusp of breaching Rule 1 with this judge, and it would do well to comply with what he's ordering here before patience is exhausted.
Sure. I mean, from a plaintiff standpoint, they did go the initial route and were basically rebuffed by the defendants. Then they requested the forensic examination. So
right.
Understood that at least the judge, held the defendants accountable for the initial requests.
Right.
So that's interesting. But Judge Peck, you said no more boilerplate objections in Fisher versus Forrest back when you were still a judge. Yet we still see them in cases routinely years later. We've covered several on these webinars, even though there are plenty of cases where boilerplate objections have been waived. So what will it take to finally get parties to stop issuing boilerplate objections?
I almost want to say it's hopeless, but what I think it will take is every judge who sees a discovery dispute will say boilerplate objection used, objections waived, except maybe privilege, period. And eventually lawyers will get the message. I mean, that's what I tried to do in Fisher against Forrest. I retired before sort of the next round of that would have occurred, but I had a sort of draft opinion ready to go saying, I warned you, and it's now waived. I also think to a certain extent, judges often look at both the requests and the responses. And if the requests are similarly out of scope and the equivalent of boilerplate requests, it's sort of a plague on both houses. But old habits, old forms, old senior lawyers who look at drafts and say, but this draft doesn't have all the stuff that I, created when I was a young lawyer, put it in. And the associate goes, but we're not allowed to anymore. Nonsense, put it in. So it, as Chief Justice Roberts said after the 2015 amendments, it really is meant to be a culture shift, but the culture hasn't shifted nearly enough all these years later.
Nope, evidently not. So we have a question from the audience is very similar to the question I was going to ask Mary. So I will ask it to you, Mary, and then others can chime in. Do you think, Mary, that a different result may have occurred if the plaintiffs proposed a forensic examination order that appointed a neutral expert or vendor to do the examination and outlined search protocols to limit what was produced to relevant non-privileged info? Mary, your thoughts?
I absolutely think that could have happened. Of course, very special Mr. Ball is in Italy, so he couldn't do it. So we'd have to call David Greedham or somebody else.
Hey, Mary, are you forgetting who's on this call with you?
Oh, you're extraordinarily special.
Thank you.
There you go. Well, we have to come up with a nice acronym for you. one of the things about apps and applications is that they usually leave a mark in the registry or whatever the organizing central place is for the device. So working with a forensic expert, something could have been tailored very, very specifically just to get at the app data, maybe the serial numbers of the data, but without things like usernames, passwords, and then personal banking or health information. So yes, this could have been done, but it takes a collaboration between the technical and the experts and the attorneys.
Yeah, absolutely. So this is certainly one of the things I thought about this case is, maybe had it been presented a bit differently, they could have, because certainly the judge, indicated that they might very, very well find the evidence through the examinations, but they would get to all this other stuff that's private. Seems like a reasonable approach to me. Anybody have any other thoughts on that before we move on? All right, then we'll move on to the next case. This is probably one of the more unique cases we've seen in a while. Calhoun versus Google is a data privacy class action that was brought by and on behalf of Google Chrome users who chose not to sync their browsers with their Google accounts while browsing the web. In this ruling, California Magistrate Judge Susan Van Keulen relayed the key facts associated with interference with the third-party production in chronological order, where the plaintiff subpoenaed defendant's auditor, third-party E&Y, for documents related to the valuation of certain user information, and the court ordered E&Y to do so after Google's protective order reduced the scope. In response to the order to produce, E&Y identified 6,322 responsive documents, but before they produced them, Google said, hey, let's review these and make sure they're all relevant. And they took a bit off the top to the tune of 6,232 of the 6,322 documents, leaving only 90 to be produced. As you can imagine, the plaintiffs didn't like that very much and moved to compel, which the court granted and ordered production of all the documents. And the court also issued an order to show cause as to why Google shouldn't be sanctioned for interference with the third-party production. Judge Van Keulen rejected Google's suggestion of no harm, no foul, and noted that E&Y, a sophisticated litigant in its own right, searched for and, in E&Y's own words, made its own good faith determination as a non-party to this case as to what documents appeared responsive to these requests, which Google took upon itself to review and significantly cull, and expect the plaintiffs to take Google's word that the culled documents were not relevant. In ordering Google to pay plaintiffs' fees and costs incurred with bringing the motion to compel in the amount of $10,836 for interference with the third-party production in the case, Judge Van Keulen stated, then as now, Google appears blind to the gravity of the error of its interference with a court order. Google's proffered justification, primarily that the documents reflect highly confidential financial information not relevant to the claims in suit, was heard and rejected by this court twice. Google's actions were and remain in breach of this court's order to produce. In short, Google's actions may have been justified in its own eyes, but not in the eyes of the court. So, Judge Peck, is there any scenario where Google's interference would have been appropriate here, or is any level of interference with the third-party subpoena not okay?
Well, it's a question of timing among other things. There are certain objections under Rule 45 that the party who gets the subpoena can make, and that the party whose data it may be does not have standing to make. So, perhaps Google could have said to EY, let our counsel act in part as your counsel as well as ours, and let's negotiate the appropriate scope of the subpoena before anybody went to court to ask the court to enforce it. But having not done that, and presumably Google had no standing in front of the court, and even if it did, the court ruled multiple times, as is set out in the timeline there. once the court has ruled, appeal it if you can, if you have the right to do it. I mean, this was a magistrate judge decision, so one could file objections to the district judge supervising the case within 14 days of the magistrate judge's order, things like that. But you can't just say, I don't agree with you, judge, so here's what we're going to do with the documents. That is a Rule 1.1 violation. You're thumbing your nose at the court, and that never goes over well.
No, indeed it doesn't. So, Mary, if E&Y had not been a sophisticated litigant, could an argument have been made for Google getting involved in their production?
Well, the argument could be made, but as Judge Peck said, it should have been made a lot sooner and before the order was baked. So, yeah, this extra QC step that they took those huge liberties. I mean, it wasn't one or two docs. I mean, they really, really narrowed it down. So, I don't think so.
No, it doesn't. It seems like maybe E&Y could have just not. I mean, does E&Y have duties here? I'll throw this out to everybody. I mean, in terms of not letting Google. I mean, I'm sure they work for Google, but they're responding to a third-party production. Do they have an obligation here to follow through with that?
I mean, if I had to guess, Google probably went to EY and said, we need to review this to make sure none of our privileged documents are being produced, and then took that, opening of the door to review for relevance. Obviously, the party who is the subject of the subpoena has obligations to the court under Rule 45. It can cooperate with its, client Google, but it's got to do what it's got to do under the ethics rules and under Rule 45.
Yeah, absolutely. So Tom, do you think an almost $11,000 order for fees and costs are going to serve as a deterrent for a company that made $257 billion last year? If not, what do you think it would take to serve as a deterrent?
Well, obviously not. Of course, that your question answers itself almost, right?
Right.
But I'm not sure that's the end of it. I mean, and please, and maybe Judge Peck, correct me if I'm just reading this too strictly here. A strict interpretation of the order. The plaintiffs were the Google was ordered to pay the plaintiff's fees and costs incurred in bringing the motion to compel, and that came to $10,836. But the judge went on to say, quote, Google's actions were and remain in breach of this court's order to produce, end quote. I'm not sure this issue is over in the judge's mind. I'm looking at that. I'm interpreting that $10,836 as just fees and costs on this particular order. But the fact that their actions were and remain in breach of this court's order to produce says to me the judge is perhaps not done, and there may be another shoe to drop here. Am I just being too particular in my reading of this?
I mean, it's possible, Tom, but my guess is it's over.
It's over. It's over.
But, in every subsequent sanctions motion to compel, whatever, the other side, assuming they're aware of this, assuming they, listen to the EDRM Doug Austin case law webinars, are going to put in their motion papers. Google, which has been sanctioned previously in the Northern District of California, blah, 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 is added again. So,
so it's a door opener. Yeah.
It will have a possible effect in other cases.
Right. I like your slipping the yogiism though. The fat lady hasn't sung yet.
There you go. Yes, I do that at the risk of we say don't piss off the judge. Sometimes it's don't piss off Google. They're the ones who keep my my blog posts in the search results. So, but hey, news is news. So there you have it. A very interesting case and interesting ruling there. So we'll move on to our last case. And this is honestly one of my favorite cases of the year. And it's not just because it was decided in my hometown of Houston. In Edwards versus McDermott International, a purported class action securities fraud case, the plaintiffs put together a list of proposed search terms that would result in about 773,000 documents with search hits, with an additional 519,000 family member documents, for a total of roughly 1.3 million documents that the defendants would have to review for privilege and relevance. Claiming that plaintiffs' proposed list was too expansive and would result in exorbitant costs, the defendants countered with search terms that would require review of approximately 650,000 documents for privilege and relevance, so roughly half. Texas Magistrate Judge Andrew Edison had a light bulb moment and said, hey.
There it is.
There we go.
We've been waiting the whole hour.
I saved it. There we go. He said, hey, I'll use the 6 proportionality factors from Rule 26b1 to decide this search terms dispute, citing his years on the bench and experience in private practice as a lawyer representing both plaintiffs and defendants in securities litigation. And as you can see here on the slide, he ruled in favor of the plaintiffs in 5 out of the 6 proportionality factors, with only the parties' resources considered to be neutral. He found that there can be little debate that the issues at stake in this case are meaningful, that the plaintiffs seeking more than $1 billion in damages weighed in favor in the plaintiffs, and that only the defendants had access to the information being sought. He even let the Texan in him slip through a bit when he said it is awful likely that the sought-after documentation is relevant and highly probative of plaintiffs' claims and defendants' defenses in the case. And regarding whether the burden or expense outweighs the likely benefit, he said the discovery door has been flung wide open and plaintiffs should be allowed to probe inside. The purported damages in this case are huge, and that indicates to me that plaintiff's proposal is proportional to the needs of the case. It is a close call, but I ultimately conclude that the scales tip in favor of plaintiffs on the proportionality analysis. So, Mary, should all judges be using the 6 proportionality factors in Rule 26b1 to decide search term disputes in federal civil cases, or was this a unique case that warranted a 26b1 proportionality analysis?
Well, there's been a concerted campaign to get judges to use the proportionality factors. So I think, it's certainly appropriate to use them, and it would give a framework to evaluate things like hit reports and requests. But I would add in there, just because something hits doesn't mean it's relevant, and so you don't know what's in that group of documents. So you could have, say, 100,000 hits. Let's say it's a construction case, and your one of your search terms is Office. You'll get every single document that is from Microsoft Office in there. Right. So I don't know that hit reports are the way to go, but the proportionality factors, that is a way to go.
Yeah. Well, and it's it's even rare that we get hit counts, because a lot of times we just get overly broad with really no information behind it. So at least we've got more information than we normally have. So Tom, how did the fact that the parties provided search term hit counts factor into the court's ruling? Should all courts require hit counts in search term disputes, or does it depend on the case?
I think it depends on the case. I mean, I don't think you want courts requiring it. I think savvy litigators will do it, will use them as part of their arguments. And the distinction here was, as you read, the claim damage in this case were, quote, huge. And the judge went on to say, I think she said right there at the end, right? It's a close call. All right. If it's a close call, you want to use everything you can to make the judge rule in your favor. And I think the hit counts help there in the argumentation. Third, not only were the damages claimed use. We have a fairly significant amount of documents here, not astronomical, but large. And so, yeah, I think it absolutely helped. And as I said, if it's a close call, if you think the judge is really looking at all of those factors, the proportionality factors, use everything you can to tip the decision in your favor.
Sure, absolutely. I long for the day when we'll actually maybe see some sampling used as well, and some kind of that information applied to a search term dispute. But haven't seen it yet. At least haven't seen it lately. But I'll keep hoping. So Judge Peck, do you see any issues with using the 6 proportionality factors in Rule 26b1 to decide the search terms overall? Or would it have been better to break down the terms and rule on their scope individually?
Well, I'm going to answer that obliquely to start. This looks like a very thorough analysis of the 6 proportionality factors. But really, it's sort of generic. Other than the amount in controversy, the requesting party always thinks the data is necessary. I'm also a little dubious about the $1 billion in damages. The plaintiff can put any number they want in the complaint, and usually it's got an extra 3 zeros just because that's the way people do it. In addition, I don't think, let's assume the $1 billion is real, that's the potential damages if liability is proved. Does that mean there should be no proportionality in discovery? I don't think so. I think you got to look at all of the factors, but when balancing the burden and benefit, what is the burden of producing twice as many documents or reviewing twice as many documents, and what is the likely benefit? Again, I just don't think it should be, it's likely that the hits are relevant documents. I don't know where the judge got that approach or theory. We don't know what the plaintiff's search terms were, what the defendant's search terms were, what is the basis for the delta. Was there one big search term that the plaintiff wanted to use that the defendant could show was getting a lot of false positives? But just the numbers and that it's $1 billion case does not, to me, allow there to be the appropriate weighing of the proportionality factors, particularly the 6th proportionality factor, the cost-benefit analysis, because this is only one small part of the entire discovery program. Yes, it's an expensive part, but presumably there are going to be lots and lots of depositions, expert witnesses, et cetera, et cetera. And at each one, if you just say, big case, door is open, go do it, I think the results are not what they should be.
Yeah, that makes sense. Yeah, absolutely. I mean, and great point about the search terms. I always found that looking at unique hits is an indicator of potentially overbroad terms, because there oftentimes.
Did we lose Doug's connection?
I do not hear him.
I heard a ding just before he went radio silent.
I did, but we're already sort of at the top of the hour. So
okay.
So I guess I'll close out for Doug. I can't necessarily think of any good dad jokes, but I do want to thank Doug for anchoring. And if you'd like to keep up with eDiscovery Today and the eDiscovery News, we've got a link under that paperclip, as we do to Tom and Judge Peck as well, and our next webinar. So thank you, Tom, and thank you, Judge Peck, for this wonderful presentation. Thank you, Doug, in absentia. Our thanks to the EDRM community for your kind attention, and tune in next month for our case law for July on the EDRM Global Webinar channel. Thank you.
Great.
And Mary, before
Thanks.
you close us out, let's just make sure the audience has seen that the July one is July 28th
Oh, there you go.
at 1 p.m.
There we go. Thank you.
Excellent.
Very. I observe your judicial notice of that date.
Thanks, everyone.
Thank you.
Bye-bye.
Bye all.